Sexual intercourse with a child between 10 and 14 years of age is an offence under Section 66, capital C, subsection 1 of the New South Wales Crimes Act. The maximum penalty for the offence is 16 years imprisonment. It is what's called a Table 1 offence, which means it can be decided in the local court or in a higher court, such as the district court. The maximum penalty in the local court is 2 years imprisonment. For you to be found guilty of the offence, the prosecution must prove three things. The first thing they must prove beyond reasonable doubt is that you had sexual intercourse with a person. And the definition of sexual intercourse is contained in another video we have on this website. The second thing is the person was aged over 10 years and below 14 years. The third is that you had knowledge of consent. This means that the prosecution must also prove beyond reasonable doubt that either 1, you knew the other person was under the age of consent, i.e. under 16 years of age, or 2, you were reckless as to whether the other person was under 16 years of age, or 3, you had no reasonable grounds for believing that the other person was under 16 years of age. Now, knowledge of consent can be determined through all of the surrounding circumstances of the incidents. For example, your previous dealings with the complainant, the context in which the incident occurred, any specific inquiries that you made about their age, and of course any responses that they gave you or that you otherwise received in respect of those inquiries. If you are guilty of the offence, the sentencing statistics suggest that in the district court, 66% of people were sent to prison. The average prison sentence was a 3-year full-term sentence, so that's the entire sentence, and a 2-year non-parole period. The non-parole period is the period of time someone must spend in prison before being able to apply to get out of prison. Now, 20% of the people in the district court were given what's called a suspended sentence. And that's a good behaviour bond which will likely result in a prison sentence if it is breached. So if you commit another offence during the good behaviour bond, the Section 12 good behaviour bond or suspended sentence, you are likely to be put in prison. Now, if you are charged, it's important to try to keep the case in the local court where the penalties are less severe. And of course, if you are not guilty of the offence, your lawyer must push hard for the case to be dropped early on or fight to prove your innocence in court if the case goes that far.